Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time that you've been allotted, we'll ask them and you'll have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting. People v. Prince Bryant. Okay, give me a moment. Five and 2 and 5. Medina versus Medina. Five and 5. H. Alisa is submitted. Rosario v. Gentry Tenants.
Respondent Gentry, 5 minutes.
Respondent Lerden Boiling, 5 minutes.
You 5 and 2 and 4 and 4. We have 3 appeals in Forster versus Bajani.
12 and 3.
I'll give you 6 and 2 and 5. People versus Luis Ortiz. Submitted. SC Children. SC Children. Submitted. Reyes v. 45 and 47 Wadsworth Avenue. Okay, 5 and 2 and 5 and 2 and 5. Judge Gesmer is recused on that matter. AT&T Mobility Holdings versus Grupo Salinas.
For appellant, I request 10 minutes, divided 7 and 3.
Your Honor, there are 2 respondents. We ask for a total of 10, 5 and 5.
Okay, I'll give you 6 and 2, 4 and 4. Hereford Insurance v. 21st Century.
Good afternoon, appellant, 5 and 2.
5 and 2 and 5. Pilapanta v. Hudson 888 Owners.
Appellant requesting 5 minutes.
Do you want any time in rebuttal?
No, Your Honor.
5 and 5. People v. Clarida. Five and 2 and 5. Justice Michael is recused on that matter. Ananda Raja v. Icon School of Medicine is submitted. Leslie Digital Imaging v. Empower Information is submitted. First case up is People v. Prince Bryant. Please.
Good afternoon, Your Honors. May it please the Court. I'm Stephen Emick here on behalf of Prince Brian, and I'd like to talk about 2 evidentiary rulings in this perjury case. First, the Court should not have allowed the ADA who presided over the grand jury proceedings to testify at trial. The case addressed basically 2 statements that Mr. Bryan made in front of the grand jury.
Counsel, can you speak a little bit more closely to the microphone
sorry.
and perhaps a little slower?
I was being too loud. Sorry about that. Case basically addressed 2 statements that Mr. Bryan made in front of the grand jury, both of which concern whether he participated in the theft of polo shirts from Macy's in concert with co-defendant Solomon Davis, The only evidence you need from the grand jury proceeding to test that is the transcript of those proceedings. And instead, in addition to that, in this case, the court allowed the ADA to testify to all kinds of details about what happens in the grand jury that essentially conveyed to the jury at trial that both the prosecutor and the panel of grand jurors, once they were able to see...
Was that objection preserved?
Yes, absolutely. There's a pretrial hearing where counsel argued that the only minutes you need, the minutes are all you need to establish this.
Your brief basically makes the point that you made a general objection, and that encompasses all aspects of Carty's testimony?
Yes, essentially, defendant's position was definitely made clear to the court, and it was the real meat of of our claim is also came in through the justifications the prosecutor presented to the court below. So yes, defense counsel made a general objection saying the minutes are all you need, this is bolstering, et cetera, but the prosecutor specifically said, hey, we want to bring in this testimony from the ADA to talk to deadlines and evidentiary developments so that we can explain, the nature
Your
and
preservation is based on the prosecutor's arguments?
No, I mean, preservation is based on the fact that this issue was clearly discussed and put in front of the court in a pretrial hearing, and the court expressly said there's no reason for the ADA's testimony not to come in. The full breadth of everything we presented, I mean, defense counsel made the point very clearly, this is just completely unnecessary. I mean, whether, bolstering is kind of just thrown in there, defense counsel was very clear that there's no purpose for that testimony, and everything that you need is in the transcript. And that is the foundation of of our claim.
Wasn't it within the court's discretion, though, for the court to allow Carty to set the stage, or, what is a grand jury proceeding for the trial jury?
So, in terms of setting the stage, I could see explaining that it is, I mean, most of this is encapsulated. Everything you need for perjury is encapsulated in the transcripts. The fact that it's testimony is going to be self-evident. The fact that there's an oath administered is going to be in the transcripts. Setting the stage in this case had the effect of basically giving a lot of extra context that ended up framing the indictment and the grand jury process as proof of guilt at trial. I mean, going through that she had to present the case within 6 days, and she didn't have the video yet, and that they returned no affirmative action. And it has, the message there is that once...
Is there a specific charge that's always given that an indictment is proof of nothing whatsoever?
Of course, but the curative...
Wasn't that given in this case?
It's mentioned, but the damage is done at that point when it's... He's saying, remember, the indictment isn't proof of anything after you have an ADA coming in to say that we reviewed this and rejected it. It's sort of doesn't
Reviewed
work.
what and rejected what? I didn't
The
understand.
security video. The issue being the extra window dressing context that was added here by the ADA's testimony is that I had to present the case without the security video. The only implication there is that once I was able to get the security video and we returned an indictment, both the prosecutor and the grand jury rejected Mr. Bryan's testimony.
Well, isn't that the explanation of perjury? The factual explanation?
Of course.
Necessary for the charge?
No, to establish the charge at trial, you can have the video and you can have the content of his statements. What you can't have is a prosecutor saying a prior panel of grand jurors and I already heard and rejected this testimony. It's when the grand jury comes in as evidence that you can't have that. And this wasn't the only issue here. If I could speak briefly to the second error that we've briefed, which is that defense counsel should have been permitted to cross-examine. Thelma Tanea was the store detective supervisor, one of the lead prosecution witnesses in this case, who, between working at Macy's and trial, went on to be a police officer where apparently she was disciplined for turning off her body-worn camera to conceal.
Yeah, she was a cop after she was a security officer, right?
Exactly. And what's at issue is her credibility as a witness at trial.
Counsel, you can unpack that more on rebuttal. Yeah, we'll want to talk to you about it, I'm sure.
May it please the court. May it please the court, Melancha Chanda for the people. So in this case involving perjury before the grand jury, it was entirely proper to have the prosecutor who conducted the grand jury proceeding to talk about that proceeding. And I just want to clarify that perjury has more than one element. It's not just the showing of the false statement. And the grand jury exhibits that were submitted just had Mr. Bryan's testimony. Now, the other aspect or the other element of perjury is that you have to show that it was material.
Counsel, can I just stop you for a sec? Is this, are you conceding then that the objection was properly preserved?
Okay, the objection to it being bolstering was preserved, but on appeal, defendant makes that wholly separate argument about that the prosecutor somehow suggested it was evidence of his guilt, the indictment. That was never brought up either during her testimony in the preliminary motion that defendant made, and also after the judge actually gave instructions to the jury in accordance with defense counsel's wishes that the jurors know that it's not evidence of guilt. There was also no further objection. So that is completely unpreserved.
Okay. I'm not sure I agree with you on that. I don't know about the rest of the panel, but why don't you get to the merits on it?
Sure, okay, so there was an element of materiality to the grand jury proceedings that were established by the prosecutor's testimony. She explained that she was under time constraints. It was the last day to present before the grand jury and get action on the grand jury before bail he would be released on bail. It reflected an incentive for defendant to impede the grand jury proceedings by begging for additional evidence, and which the grand jury obviously took into account by voting no affirmative
What
action.
element of the perjury charge does that go to?
On the perjury charge, it shows the materiality of the false statements in impeding the proceeding as it was charged to the jury at trial. So it's not just you showing the false statements, you have to show that the false statements were material in the grand jury action, and that's what she established through her testimony. So it was not established by just the grand jury minutes alone, which were just his false statements. So there's two elements to the perjury charge that needed to be established. And in terms of the newfound claim that the prosecutor somehow indicated that the indictment was evidence of guilt, there was jury instruction that clearly the jury followed because the jury did acquit of the grand jury charge. That's the basis
Of grand larceny, yeah.
And I do want to point out that I know that counsel might say this on rebuttal, but evidence of the perjury counts were wholly independent and were really established mainly by, you could say, Davis's testimony. And Davis's pointed him out on video, pointed him out talking with him for 20 minutes outside Macy's, and then pointed him out in the section of the polo clothing section. So the same person who defendant says got him the acquittal on the grand jury charge established, along with the video evidence, that he did give perjured testimony.
What about the cross-examination of Thelma Timeo?
Again, that command discipline was of a technical violation of not following the procedures of the body cam. There was no substantiated finding that she was somehow dishonest, that she was trying to conceal something going on between her and her colleague.
But there was a substantiated finding that she committed some misconduct, right?
That she didn't follow the procedure of the body cam footage by turning it off, but those weren't relevant to her honesty because there's no substantiated finding of that. But in any event, Teneo was an ancillary witness because the main witness who talked about actually seeing the theft was Garcia, and also he was acquitted of the grand larceny charge. And again, the perjury conviction was based on wholly independent and overwhelming evidence. So for that reason, we'd ask this court to affirm. Thank you very much.
Thank you, counsel.
All right, so as to Ms. Teneo, as far as respondent says there's no finding that she was dishonest, the discipline is for turning off her body-worn camera footage, her body-worn camera, taking it off to have a private conversation with her partner that's not recorded. I mean, that's exactly the kind of allegation that goes to credibility of a witness at trial. It's almost perfect impeachment material. The idea that it could go to her credibility as a supervisor beforehand, as if there's like sort of time jump issue, I don't really follow it. It's her credibility as a witness that matters, and it's just a plainly incorrect ruling. To the extent that Mr. Bryan's, I feel like some of the arguments here misunderstand the significance of his acquittal for grand larceny. The perjury counts are not wholly separate. Both the charges of perjury really hinge on, and it's in the bottom paragraph of the indictment, whether he participated in a larceny. They hinge on the fact that, the charges say he was lying because, in fact, he participated in this theft of polo shirts. They're linked together. To say, to the extent the split verdict, which is interesting and unusual, suggests that they were parsing the credibility of individual witnesses, I mean, that just means the ability to impeach a witness like Ms. Teneo, who was the lead witness for the prosecution in this case, is all the more important. And the same goes for the perjury counts. You can't have an ADA leading the jury to say that the grand jury reviewed all those extra peripheral details, vouching.
Were they extra peripheral details, or did they go to materiality as your
They
adversary?
absolutely do not go to material. Not to cut you off. Sorry, I'm running out of time. But I didn't mean to. They really don't go to materiality. Materiality is, all you need is the substance of the statement for that. You have that in the text. And materiality is whether it tends to circumstantially support or tends to support a fact that's an issue. And when you have, yes, there's a risk of this contaminating influence. Whenever you have a perjury count that addresses a grand jury proceeding, but it absolutely doesn't go to materiality. Sorry.
Thank you, counsel. Thank you both.
For interrupting.
Medina versus Medina.
Good afternoon, Your Honor. So as you know, my client submitted a motion to vacate a separation agreement which was signed many years prior to the action for divorce.
And the reason that your client was seeking to vacate that separation agreement was because he contended that at the time he didn't speak English and didn't understand what was in the papers, right?
That and the fact that he said that he was outright the victim of fraud and that he was told to sign this separation agreement as part of an immigration application and not as a separation agreement. So he had.
Right, and the fraud was that he didn't understand it because he didn't speak English.
Well,
Didn't understand what was written in the document
Correct.
because he didn't speak English.
so in 2004, when he signed the agreement, he did not understand what was written in the document because he did not speak English.
Right, and now he speaks what he termed in his affidavit as broken English.
Correct. So he speaks English, not as fluent, I guess, as the standard person, whoever that is.
Counsel, to the extent that the issue is whether Mr. Reyes was able to read and understand the affidavit that he signed, is his ability to speak English either fluently or in a broken manner as described, is that enough?
Yeah, so the point of the translation and the point of anything is to,
Well, when you say anything, just so
the
that
point of the
we're
translation
clear,
and the point,
just so that we're clear, you're talking about the statutory provision that if someone does not speak English and understand English, yet submits an affidavit in English, they must submit also a translator's affidavit,
to
right?
ensure that that person understood what they were submitting to the court.
Right, in the event that they're held for some sort of perjury
Correct.
based on that document, right?
Correct, and that's not at issue, right? His understanding is not at issue. The technicality of whether the affidavit that was submitted to certify the translation, whether that is sufficient.
Hold on, I'd like to back up here a second. Let's start with the first affidavit that was in English.
Correct.
Are you conceding that he didn't speak English with sufficient fluidity that he needed to have a translator's affidavit?
I'm not. I'm saying, no, I'm not.
Okay.
Just to be clear, I'm not saying that, right? So part of what I'm saying is that CPLR 2101B does not apply because he speaks sufficient English to be able to understand the affidavit.
And that sufficient English in his affidavit was phrased as broken English, right?
It was phrased as, because that's the common term, right? That's when an individual does not speak English with the same fluidity or the same
Fluency?
I guess,
Fluency.
Fluency, yeah.
I
know what you mean.
as a person that was born here, people term it that way.
Well, so let's just talk about it in terms of English being someone's second language, right?
Correct, yes.
Okay.
Second language and also accent, right? The way that they pronounce words, et cetera. But that does not speak to the understanding of the language.
Nor does it speak to his ability to understand written English.
It doesn't speak to that, but that's not, again, that's not an issue, right? No one,
Well, it is kind of an issue, right? Because if he's submitting an affidavit in English, but we start this case out from a standpoint of 20 years ago, he didn't understand any English.
Correct.
Now he's submitting an English affidavit.
Right.
And in that affidavit, he says he speaks broken English.
Right.
It matters whether
No.
he could understand what was written in the
that
affidavit.
is absolutely
Counsel,
true. It matters.
Justice Michael does not need my help, but always wait for the question to be.
I apologize.
Thank you.
I'm sorry. Yes, it matters that he understands. And again, he has never said that he did not understand the terms of the affidavit, and no one else has ever said that he didn't understand the terms of the affidavit, right? So when I say that is not an issue, I mean that no one has made it an issue. I do understand that at the heart of it is his understanding, right? That is at the heart
Certainly, I guess the spouse or the ex-spouse could have put in an affidavit saying, I know this guy does not speak English very well.
Correct, and she did not, right? And then the irony of the whole thing is that the net effect of this is that he is going to be held responsible for an agreement that is written completely in English, and there is no affidavit or translation attached to that agreement, right? So on one hand, they're holding him responsible for an agreement that is written completely in English, as if he fully understood it then, right? And he was perfect. I'm sorry, it's red. Can I finish?
You can finish the thought.
Right? But right, when he attacks it, right, the instrument is being held to a higher standard if the court, by the court, right? So the court is saying, well, this affidavit was not properly translated, right, or did not comply with 2101B for the attacking instrument, but not the heart of the entire thing, right? So this is wholly inequitable and unfair to Mr. Medina.
Thank you, counsel.
May it please the court, my name is Marilyn Sugarman. I represent the respondent wife, Christian Medina. I'd like to address the last point made by counsel first. He concedes in his reply brief at page 5, and it's also in the decision, that if the court rejects the affidavit, which was made in support of the application to vacate and set aside the separation agreement, there's no reason for a hearing, because if you throw out the factual affidavit, you can't get to the issues.
Right, but the question is whether there's any basis for throwing out that affidavit. And I don't see anything in that affidavit that suggests that Mr. Medina didn't understand the affidavit. And your opposition papers don't give us any reason to think that Mr. Medina didn't understand that affidavit. So I'm not sure how the motion court got to the position that it did, that it should throw out the affidavit.
So, Your Honor, to answer that question and the questions raised before by Justices Michael and Gonzalez, he said in his affidavit that he speaks broken English. He
Right, and
didn't
that
say
doesn't
anything-
address, excuse me, that doesn't address.
Well, but he
Excuse
didn't.
me. I agree with you, that's what he said, but that doesn't address what his level of ability to understand written English is, and that can be a very different thing. So I can't infer from the fact that he says he speaks broken English that he can't understand the affidavit that he signed. Can you show me anything besides that to support your claim that his affidavit shows that he didn't understand it?
It was incumbent upon him to come forward and say he had some level of fluency of reading and
Why
writing.
was it
which he
incumbent?
didn't do.
That would make it incumbent on everyone who signs an affidavit to say that, for whom English is not a first language.
His admission essentially is that 2 months later, he submitted the affidavit of translation.
But 2 months later, we're not at 2 months later. At the time he submitted that affidavit, why was it his obligation to say he understood what he signed? It seems to me that you're making that into an obligation that would be imposed on every person for whom English is not their first language, and I don't know anything in our laws that require that.
Well,
He was the
counsel,
one
is
who
it
came
grounded
forward.
in the fact that this case started out based upon him saying a fraud was committed against him because he didn't speak or understand English?
Exactly. He's the one who
But
affirmed
that
it
was 20 years ago. So the question is, based on our case law, is that what do we have present in the record to support that he didn't understand English now, such that he could not have submitted an English affidavit without also accompanying it with a translator's affidavit.
Okay, so two points in response to that. He didn't submit the translator's affidavit simultaneously. It was 2 months later.
Well, that's not really, that's of no moment, right? Because the question is if he had to submit that, right? That's the first initial question. Was there a requirement for him to submit the translator's affidavit? And there's only a requirement for him to submit a translator's affidavit if the record supports that presently he does not speak or understand English. Where is that support in the record here?
The support is his own admission that he speaks broken English.
So you're connecting broken English, the ability to speak broken English, to also mean that the person does not speak or understand English, such that if they submit an affidavit, it has to be accompanied by a translator's affidavit?
Yes, because
Okay, I just want to know your position.
CPLR 2101 is clear. It's been interpreted, no pun intended, that when the proper procedure, when someone doesn't understand English with fluency, is that they have to submit the
The
translator.
case law doesn't say fluency. The case law says if the record bears out that a person does not understand or speak English and submits an English affidavit, they have to submit a translator's affidavit. The problem here is that saying someone speaks broken English doesn't also mean that a person does not read or understand English.
I agree with you, except then why did he come forward with the translator's affidavit 2 months later and then
Is it because you objected?
Well, I didn't represent, I
Well,
didn't appear
not you,
below.
but your client's then counsel
My
objected.
client's then counsel objected to the original affirmation.
Right,
that
and
prompted-
the reply on that is really a paragraph that says that the plaintiff doesn't believe he needs an affidavit of translation, but if he does, right, it's an if, I'm going to cover myself, in the alternative, here's an affidavit. That doesn't establish definitively that an affidavit was necessary.
Please answer. No, the red light is on, but please go on.
Okay. Again, it may seem like circular reasoning, but once he came forward and said, I speak broken English, that raises the issue, and that's why they came back on the other side, I assume.
So you're basically asking the court to say, as a general rule, that if someone says that they speak broken English, that therefore also means that they do not speak enough English in order to submit an English affidavit without a translator's affidavit.
Well, I'm not just saying that. This court has said it.
No, the court says if someone doesn't read or understand English, there's nothing in the case law about broken English. It just says read or understand English.
With respect, Crone versus Reyes, in which you were on the panel and Justice Moulton was on the panel, talked about a non-English speaker's affidavit. And the broken English...
This is not a non-English speaker. He's a person who says he speaks broken English. That's very different. He speaks English. It may not be, the English that a native speaker of English would speak, but he speaks English. So the case you're citing is not on point.
The definition, essentially, of broken English...
That's an interesting question. I don't know that that's a term of art that has an agreed-upon definition.
And we're not finding that in Black's Law Dictionary, are we? Where are we finding the definition of broken English?
Not in Black's, in Merriam-Webster.
Who?
In Webster.
Oh, we are? Okay.
I don't think you cited to that in your briefs.
I didn't, but it carries the meaning that you speak English in a non-standard way.
I'm sorry, I don't know that means that you can't understand it or read it.
Well,
They're very different skills, whether you speak a language, understand a language when you hear it orally, or whether you can read it. They're very different
I understand
skills.
that, but in particular, when you're submitting an affidavit in a legal proceeding where there's legalese and when there's other terms that are not commonly used, in everyday English. To admit that you speak broken English and then be absolutely silent as to your ability to read and understand anything else more than implies that you need to have it translated to you in
CPLR
Spanish.
2101 doesn't address that situation, does it?
The CPLR 2101 doesn't
Does it on
expressly
its
say
face
that, but
address what the claim you've just
the
made?
practice commentaries say
Counsel,
that-
I asked you if the statute specifically addresses that.
the statute specifically talks about papers being served and filed in the English language. The practice commentaries, as applied by this court, say that if a person who signed the paper does not speak or understand English, the proper procedure is to submit
But
the
the
paper.
question is, there's never been no foundation for your claim that he doesn't understand English.
And
So in the absence of that, why would we apply this?
because I submit that his submission of the translator affirmation 2 months later is an acquiescence.
Why
Where-
isn't it boots and why isn't it a belt and suspenders? He's attacked on that basis. He says, look, I understood it fine, but just so you know, it was also
Because
translated.
there's no
to me."
evidence that he said that.
Thank you. Thank you both. Rosario v. Gentry Tenants.
Good afternoon, Your Honors. May it please the court. Brian Isaac, I represent the plaintiff appellant in the matter. My argument is simple. If you take the plaintiff's testimony and you disregard it, throw it out. I still have a labor law violation. And I believe the rule of law from this court is that if you're going to use human beings as elevation device substitutes, you know, if they're carrying instead of a hoist, instead of a crane, then if the object that they're holding falls, moves, they lose control of it, you have a violation of labor law.
No, but even there, Mr. Isaac, isn't there some divergence in what happened when they were trying to get this thing up the stairs using the cart, the dolly?
There was certainly divergence in the testimony.
And you say that those accounts are disingenuous, I think, in your reply brief. What do you mean by that? I mean, just, they were, first of all, they diverged from each other, so that makes it look even more credible, perhaps, because they didn't follow a script. So what do you mean by disingenuous?
So let me tell you what I mean in terms of what's happening. If you take the plaintiff's testimony, you throw it out. You take a look at the two people who actually know what happened. Both say that there was a loss of control of the device. You've seen the photographs there, authenticated photographs. They're in a very, very small area. You have 4 people pushing up this cart.
Did you say 2 people said there was a...
4. 2 people up front, 2 people in the back.
They said that there was a loss of control?
Yes, they said that, one said that the plaintiff slipped. The other one said that the plaintiff screamed and he saw the plaintiff slip. Policastro said he put his rear end on the ground and got up. I just want to make sure I have the right
I
person.
don't know that you're exactly paraphrasing what their testimony was, but go on.
Well, I can give you the pages, Your Honor. If
We have those.
I'm sure you do, but Policastro said that.
That's the case. Yeah, we have the citations.
I'm sure you
Your
do.
brief is very thorough, but even if that's the case, I mean, what about causation? You know, in other words, one guy said, I forget who, Policastro, I think, said he went to the stairs and then he popped back up. You know, and then they finished the job. They got the thing up the stairs. And so, isn't there an issue about causation?
No, there isn't, because that would be an issue that I would submit to you. It goes to damages. If the defendant wants to say, look, he didn't get hurt because of this happened, that's fine. They still have that. Summary judgment doesn't mean I win the case. It doesn't mean I get any money.
But counsel, it seems to me that another bar to your getting summary judgment is the fact that one of the coworkers claimed that the plaintiff tried to bribe him to tell the story as the plaintiff had. Isn't that something we have to consider in deciding whether the plaintiff's entitled to summary judgment?
Well, I think that that's a completely collateral issue.
Why is it collateral? If he tried to bribe somebody to support his story and I can't think of another labor law case where someone submitted affidavits from 3 coworkers describing the incident differently from the way the worker did, and then one of them comes forward and says, and the worker tried to bribe me to say it his way. I've never seen a labor law case like that.
Well,
So
I haven't seen it either, but I think my point is, Judge Gesmer, that if you look at the person who gave that testimony, that's one of the people who also said that the accident happened when the plaintiff screamed and slipped. which is consistent with what Paulo Castro said. So to me, it's something that was denied. It was expressly denied, but be that as it may, that's not material to how the
Counsel,
incident
aren't you
occurred.
leaving something out? There's a convergence of opinion by the, I'm going to use the word opinion loosely, all right? As to the three, I'm going to call them three co-workers who were, along with him, pulling or pushing this water tank up. Those three persons all say the water tank never fell on the plaintiff. It could not have caused his accident by falling on him because it did not happen. So don't we have an issue of fact that automatically means a denial of your motion?
Judge Gonzalez,
The motion.
I see like I'm a salmon swimming upstream, but let me try to switch this up.
We like salmon.
I do too, but I wouldn't want to be one swimming upstream. But again, I am not suggesting to you that there are not different versions between the plaintiff and the defendants. There are. It's complete. But my point is, if you take what they said, okay, whether it fell, whether it moved, there was a loss of control of the instrumentality. And if you look at
Well, what they said is that it shifted, but not that that shift caused an accident that harmed the plaintiff.
again, in our opinion, that is a claim that they can make with respect to damages. If you look at your SCO case.
Oh, so the shift alone is enough, even though it didn't cause an accident?
They can, if you have a bifurcated trial, as you know, the question is, was there negligence, was there a violation of the statute, and was it a cause of the accident? On the damage trial, the issue is, was it a cause of the injuries? They're two separate issues. And again, I would just ask you to look at the SCO case where someone lost control of an instrumentality when they're going down I guess a ship ladder, and the argument was the plaintiff hurt his back. And the court said that was a 240 claim. So I'm not saying that I win, I'm not saying I get $10 million, I'm saying that that's a separate issue that the defendants can still raise at a trial, even if you grant summary judgment. Thanks for listening.
Thank you. You have time to rebuttal.
Good afternoon, Your Honors. Kevin Murtaugh for the defendants Gentry, excuse me. Essentially what we're saying, Your Honor, is that there are factual issues here which would mean that the plaintiff is not entitled to summary judgment. Essentially,
Counsel, is the labor law violation merely the shifting of this object?
but there's testimony here that there wasn't a shifting of the object. There's testimony in the record, Your Honor, that in fact what happened was he lost his balance. Nothing shifted. So in other words, the water tank was never had to be reassessed, reestablished on the hand truck. There's testimony that there was actually a ratchet strap there, and in fact, Your Honor, that they never reset it. They never reset that, Your Honor. So therefore, I would submit that no, there was nothing like that, Your Honor. So our position is that this question of fact.
I'm sorry, you're saying that the shifting that's described by Mr. Polacastro automatically means that there's no issue as to causation because the shift was caused by the water tank, or is there a question because the shift could have been caused because somebody fell, and then when they fell, their hold on the cart? That's not a cart. It's
a hand truck, Your Honor.
Hand truck. Thank you. Was lost or modified.
Your Honor, there's factual disputes in the record as to what happened, but what we're suggesting, Your Honor, is that when he slipped, that's when it fell over. But nothing shifted, okay, Your Honor. It fell simply because he lost his balance. And what we're saying, Your Honor, is that once he regained that, and then they went up the stairs again, they never had to reassess or put the water tank back on the hand truck. They simply just went up again, and everything was fine. What we're saying, Your Honor, though, is that there's questions of fact, so many questions of fact, one of which was alluded to, which the credibility of the plaintiff himself, in stating that Mr. Gill, who stated that tried to bribe him with regards to this.
That's a major concern, of course, for anybody.
Yes, Your Honor, and I think that certainly if summary judgment is granted, that fact would never come out. But the credibility of the plaintiff here, Your Honor, is not.
Yeah, counsel, maybe your relationship to the microphone is causing that light feedback.
Oh,
I'm not sure, I'll tell you the truth, but talk directly into the microphone, see if that helps.
Yes, Your Honor, I'm sorry. What we're saying, Your Honor, is that that is not the only issue of credibility. The other three people that were there, they didn't testify that the accident happened in the manner in which the plaintiff did. You have to show an inadequacy of a safety device. Your Honor, here I don't think that they have shown that.
Well, there's a question as to what the safety device was insofar as the plaintiff describes it as a rope that secured the water tank, and the others talk about a ratchet snap.
Yes, Your Honor, and in fact, that issue didn't come up at the plaintiff's deposition because he testified through a translator, and the translator testified, said that it was rope. However, the other witness that you're alluding to, Your Honor, what he said was that he clearly identified this particular device not as a rope because he said it had to be tightened. He identified that's a ratchet strap, Your Honor. And what we're saying is that the adequacy of that safety device is a question of fact for the trier of fact. And
Why?
why? Because again, certainly, again, testimony in the record, Your Honor, that in fact that it was adequate. It did not move. It's testimony in the record that it never moved.
So did all of the witnesses, though, provide a narrative that was consistent with the plaintiff sustaining an injury as a result of his work?
No, I don't think so, Your Honor.
Okay.
I don't think so, Your Honor, no.
That's like, I think, a threshold issue here. Because oftentimes the question of adequacy isn't the most defensible terrain for people on the defense side,
True.
correct? Where
That is
an
correct, Your Honor.
worker is injured. So, some of our cases indicate there's a presumption is triggered, especially with A-frame type ladders, and I realize that isn't this
Yes.
case. But I just wanted to know that fundamental point, whether there is disagreement among the witnesses as to whether plaintiffs sustained an injury as a result of the work.
There is, Your Honor. As a matter of fact, one of the employer's witness testified that in fact that she spoke to him after the incident, and how did the day go? Everything was fine. 2 or 3 of the people who were there helping hoist up the boiler testified that they didn't see anything happen at all, Your Honor. So there is testimony in the record to that effect.
Thank you, counsel.
Thank you, Your Honor.
Good afternoon. My name is Melissa Cowan, and I represent the respondent, Laird Boiling Works Incorporated. May it please the court, the undisputed fact about this case is that almost every issue of material fact is disputed. And I'm just going to start off by clarifying that the standard that's proposed by appellant is not the standard under this court related to 241. It is not just whether or not an object fell, but it's required to show that it was due to the fact that there was an absence or inadequacy of a proper safety device. That is a material question of fact that we have here. We can even back up and state that the first question is whether or not this accident happened. A lot of testimony.
Well, that would be a causation question, as Justice Higgett was talking about, right?
Well,
in other words, even if something happened, did it cause an injury?
Yes, but before, I think you have to back up and say, if something happened, is it a type of accident that the labor law even applies to? So I don't even think that's the first inquiry. And then after that, you have to go through even more. There's just not the next question after the next question. So even if we get to, okay, an accident did occur, is it a type that, well, how did it occur? Because then we have various accounts of how that accident occurred that are completely contradictory to what plaintiff says, including by one of his former coworkers who testified very clearly that plaintiff called him very close to his deposition and tried to bribe him money to provide favorable testimony of this accident.
So you need to know whether in fact an accident occurred, how the accident occurred, whether the accident was the type that would trigger the protections of Labor Law 240, and whether if a device was provided, that device was inadequate for the task assigned.
Yes, I think here, though, you would have another question, which is, what safety device was provided? Because we have conflicting testimony about whether or not it was a rope or a ratchet strap.
Viewing the evidence in a light most favorable to you as the non-moving party, are one or more of those issues undisputed?
Then if that's the case, then we would submit that there was a ratchet strap used and that it was sufficient. One point I did want to also state was this word that they keep saying about this hand truck or water tank shifting. I don't understand why this is being brought up so often, because there's no dispute that the water tank was being moved. It has to shift in order to move. So when they keep saying that the water tank shifted, I'm not really understanding what that means.
I assume that meant relative to the hand truck, that it shifted so that it was no longer stable on the hand truck.
And we have testimony from Brian Pelascro that the water tank never shifted. It was always balanced on the hand truck, and that at the only slight shift was the hand truck with the water tank always maintaining its balance that dipped slightly when plaintiff let go, which then he was able to just extend his other arm and secure it.
I have another question. Is there any relevance to your position, the statement, I believe it was by one of his coworkers, Mr. Gill, that had the incident occurred as the plaintiff stated, that he would have actually not been mildly injured but crushed?
That is correct.
How is that relevant to your argument?
Well, there's 3 individuals there, all in a close proximity, and this was, the testimony is, I believe it was about 300-pound water tank. If this falls on you, it would require assistance from others there to lift it, and presumably if a 300-pound object, metal object, falls on you, you're gonna know. Especially if you're standing right next to the person, which all these 3 people were right next to him the entire time. It wasn't like anybody left, they were there.
Thank you, Counsel.
Thank you.
Your Honors, I have 2 minutes. I won't go over my time. I don't think I made my point on the causation issue the way I should, so let me try to do it a little different way. Assume for me that I'm on a ladder. The plaintiff says, I fell and I hit the ground. And the defendant says, he didn't hit the ground, he hit a bed. He wasn't hurt at all. Undisputed, the ladder moves. Do I lose on a 240 sub 1 claim, or do I win on a motion for summary judgment? And is that an issue that goes to damages? That's my argument on that. I think that kind of synopsizes it.
Sir, is it undisputed that your client sustained an injury as a result of this work, during the course of performing this work?
From the testimony of the witnesses, no, they're not doctors, but I can give you the pages.
Well, the reason I ask is because if no injury was sustained at all, regardless of the gravity of the injury, no pun intended, then there wouldn't be a Labor Law 241 violation, right?
There could still be a Labor Law 240 sub 1 violation, there just wouldn't be any causation, right? That's the basic argument. That's why I tried to come up with a hypothetical when I was sitting over there and listening.
But it would have to be, the violation would have to be because there was a device that was provided proved to be inadequate to shield the worker from an elevation-related hazard.
Correct. But under Runner and under your decisional law starting with Marrero, which was my case, you don't have to have a falling object or you don't have to have a falling person where you have a device, and this is certainly a device that has the weight because it has 4 people moving it upstairs. That can be a Labor Law violation in that situation.
Under like Quadrochi, it would have to. This is something that would have to be. It wasn't an object that was being secured, but it needed to be secured for the purposes of the work.
Correct. And the way I read the decision, if you look at Cologne and you look at SCO, if you're using people as elevation devices, which you can do, I don't think it's the smartest thing to do in a 240 case, but you can do it. If the actions don't work, if you lose control, if you drop something, that's a violation of the Labor Law. So I'm not saying that I get a penny. If their argument is he wasn't hurt at all, that's an argument that they can certainly make at trial, and if they win, I get no money. Thanks for listening to me.
Thank you. Thank you all. Next case is in the matter of the petition of Paul S. Foster, Esquire. Mr. Bijani, am I pronouncing your name correctly?
Bijani, yes.
Bijani. You have 6 minutes in your initial presentation, and then after your opponent speaks, then you have an additional 2 minutes. Please commence.
I'm trying to get my computer to open up. PC.
And obviously, you have raised a number of issues. You have 3 different briefs in these 3 different appeals. So perhaps pick your strongest points. But you're really entitled to speak about anything you wish.
Yeah, just give me a second, please,
Sure.
because I'm not used to this computer. My printer gave up before I came. I'm sorry, I did not hear your question first.
It wasn't a question, it was just a statement, because I know you're pro se, that you can raise any issue you wish, but we may not be able to have time to get to all of them, so you may want to prioritize an issue or two. That's up to you.
I requested 12 minutes for the first part. I was just granted 6. Is that what it was? I requested 12 minutes for my presentation.
I know, sir.
You know that, okay.
You have 6 minutes, so you use it well.
Okay, okay, you have my name. I'm the pro se appellant in these appeals challenging the surrogate court's decisions that overlooked critical evidence of fiduciary misconduct by petitioner Forster and co-administrator George Bijani. Forster's motion to practically double his legal fees from $41 to about $80,000 plus after the initial summary judgment compelled my timely defensive filings.
Sir, could you bring the microphone closer to your mouth?
I'm sorry.
You can just pull it closer.
Okay.
Yes. And speak louder if you would.
Sure. No, I forgot what I was. Sorry. Okay. Okay, I'm going to rephrase that or say it again. Forster's motion to practically double his legal fees from $41 to about $80,000 after the initial summary judgment compelled my timely defensive filings for the first and second amending appeals. The second was the amending one, which is not cited here only in this calendar. Now, misrepresentations to this court, delaying proceedings over a year, forced perfecting the fourth appeal, which was filed defensively initially. Far from vexatious, my actions have been reactive to their domicile deception, invoice fabrication, bad faith negotiations, and procedural harmful maneuvers. I seek de novo review of the facts to mainly vacate these decisions, impose surcharges, and reallocate fees equitably. Now, going to the abandonment issue, the decree submitted 21 days late without good cause shown to the surrogate, plus flaws like short review time, should deem the proceeding abandoned under NYCRR 207.38b. Per matter of SACO 97, New York 2nd, 436, excuses here are irrelevant. Strict compliance voids it, as in Funk versus Barry, 89, New York 2nd, 364. Their busy defending summary judgment excuse is hypocritical. They invoked my December 2023 stay distribution only, while distorting my 2018 stay motion, omitting 6 pages, hiding misconduct, and to claim that this appeal is baseless. That 2018 motion was my pro se plea for time to hire counsel amid alarming discoveries. It was a raw desperation before lawyers got involved, highlighting genuine pre-lawyer evidence that drove objectants' reactions. It showed domicile's risks to Nada, my sister, under Lebanese law, George's vow to deprive her linked to our father's disappearance investigation initiated by Nada, and potential post-New York petition challenges in Lebanon to correct distribution. Invoice fabrication with Andres, New York burial, no 14 days catering, website anomalies after my call with Forster. It shows Forster's claim the court denied the AED, affidavit establishing domicile in 2010 by accepting Lebanon as the domicile based on a New York authority having accepted Lebanon, alluding to what we now know to be the stipulation reserving domicile, discovered in the court's file in June 2024. Additionally, it revealed, I'm still speaking about the 2018 motion, It revealed that objectants did not wish to release anyone as part of any settlement agreement due to information that the personal injury case was settled out of court in 2012. Most importantly, it revealed that objectants initially forewent objections, deferring to peace, despite the questionable items in the petition. This tampering warrant investigation and flows directly to the overlooked fiduciary misconduct. Now, these appeal decisions aggrieve me under CPLR's 5511 by imposing direct financial harm, forcing me to bear approximately 66% or nearly $195,000 in total legal fees across all counseling, including mine, based on a flawed formula that overlooks misconduct as the root cause. Breaches of duty under SCPA 711 requiring utmost good faith. Despite the 2010 AED served twice on Forster, he persisted for 7 years relying on George's false information. This wasn't innocent. He admitted knowledge in a 2018 audio recording whose veracity his opposition subtly concedes by quoting verbatim without challenge, yet filed the 2010 stipulation reserving domicile.
Thank you, Mr. Bajani. The red light is on. So you have, now we'll hear from the other side, and then you get an additional 2 minutes.
Okay.
Thank you. Please.
Good afternoon, Your Honors. May it please the Court, Benjamin Ali, Yankwood LLP, for the respondent, Paul Forster. The decision of the Surrogates Court, the decisions should be affirmed in their entirety. Paul Forster is a respected lawyer. He was co-administrator of the estate in a matter where the decedent died more than 15 years ago, and the asset in the estate mainly was a settlement of civil litigation arising out of the decedent's very tragic death. What ensued thereafter, and in much of the intervening time, was a torrent of needless litigation, which mainly arises out of two claims of petitioner, pro se Joseph Bajani, one regarding a funeral invoice from Lebanon for $22,000, and the other, the initial decision that the domicile was Lebanon, which was mistaken and later changed prior to any objection being made. The lower court, the Surrogates Court, rejected those claims entirely based on a careful review of the evidence. There was a prima facie case supporting summary judgment. There was no evidence of fiduciary wrongdoing.
So here's a question. To the extent that, I want to get the brothers straight. Mr. Joseph? Is this person here, right?
Yes, Your Honor.
Okay, thank you.
Yes, Your Honor.
To the extent that Mr. Joseph did a great deal of investigation to ascertain the correct domicile and also procured documents to show that there was a discrepancy in the funeral expenses invoice, should he be charged any amount of attorney's fees against him?
Yes, Your Honor. The lower court's decision on attorney's fees is fully supported. And as to the second of the two items I'll address first, Your Honor, as to the funeral invoice, what the lower court found is that the litigation generated by Joseph, and forgive me for referring to him by his first name, but for
Me too, but
for clarity, Your Honor, was 6 times or more the amount of the funeral invoice in total, and that's to say nothing of the fact that it would be divided in equal thirds, which this estate is being divided in equal thirds. So really a $7,000 potential savings to each of the two other siblings who did not submit the invoice. But Joseph, in his pursuit of the argument that Your Honor is referring to, the investigation Your Honor referred to, generated over $100,000 in legal fees. And as to the first matter, the domiciliary, I'm not sure there was a great investigation, or I'm not weighing in on the merits of the investigation, but my client, Mr. Forster, there was a mistake as to the domicile. It was a good faith mistake. The decedent was from Lebanon, was from a prominent family in Lebanon, was staying in New York in a hotel, and was thereafter, following her tragic death, buried in Lebanon. But upon that mistaken domiciliary, the change was made to New York prior to any objection being made. So thereafter, what ensued was needless and wasteful, which is what the lower court found in apportioning the attorney's fees the way that it did. Your Honors, I thank you for your time. Unless there are further questions, we'll rest on our submissions.
Thank you, counsel.
Thank you.
Your Honor, I first would like to address what Mr. Ali just said. He bases his entire argument on findings by the surrogate court, which is based on many overlooked material facts and evidence. So everything that the court found is really subject to de novo review and changes completely after all the evidence are reviewed, because many documents were overlooked. He makes no mention of the AED, the affidavit to establish domicile, which Forster received twice. So and he admits in the audio that he had it, but could not use it because he had made false sworn statements before the courts. So that's just pointing out. Now, I would like to finish what I can from my presentation initially, if I could. Okay? Now, on the domicile issue, okay, I was talking about the agreement. I was speaking, forgive my English at times, please. Despite the 2010 AED served twice on Forster, he persisted for 7 years relying on George's false information. This wasn't innocent. He admitted knowledge in the 2018 audio recording whose veracity his opposition subtly concedes by quoting verbatim without challenge, yet filed the 2010 stipulation reserving domicile to evade scrutiny, evidence ignored by the court below. When caught, he claimed recent discovery in a false sworn statement to amend. Now, the 22,000 fraudulent invoice was 2013 stamp on a 2009 document, self-impeached by its own replica narrative, which they used to justify the invoice when they were caught with the stamps mismatching. They presented a new replica, bearing the trace of a replica. According to them, also, we do not believe it was correct. It was also fraudulent. But that did not take away the 2017 invoice, which is still in a record, doesn't have the replica trace on it. That means the invoice, both of them remain fraudulent, both invoices. They're still in the court record. Now, overlooked document and facts. Overall, the verified supplemental objection and counterclaim pleadings overlooked completely. Ajib's affidavits on Lebanese procedures ignored. The audio is ignored. Critical material disputes and credibility issues precluding summary judgments under CPLR 3212B.
The red light is on again, Mr. Bajani. You make these points in your brief. Thank you very much, and thank you, counsel.
Okay, thanks very much.
Alidis Reyes v. 45 and 47 Wadsworth Avenue Company. Justice Gesmer is recused on this matter.
I'm a respondent. I'm a respondent. Who goes first? Me?
I think Verizon was the first appellant, correct? Yeah.
Good afternoon, Your Honors. May it please the Court, Robert Conboy on behalf of Appellant Verizon New York and Respondent Empire City Subway. The trial court erred in denying Verizon summary judgment. As Verizon established, prima facie entitlement the same through the undisputed testimony of both the ECS record searcher.
Right. Your point is that one is allowed to prove one's case through a witness that is not necessarily an employee, although I know there's an issue about that because he was employed by a fully owned subsidiary of your client, correct?
Correct, Your Honor.
It doesn't matter whether he was or not.
Exactly.
That's your point.
Right. So that the trial court denied the motion based on that the witness from ECS only testified on behalf of ECS. And our position is that Verizon is able to use any admissible evidence in the record to support their motion for summary judgment. And additionally, ECS is a wholly owned subsidiary of Verizon. The work that was being done at the direction of Verizon, and Verizon owned the subsidiary conduits that were being placed in the roadway. And Verizon didn't take part in any of the work that was being performed. ECS and NICO were the only two contractors that performed any work at the location. So it's our position that the trial court erred in denying summary judgment as to Verizon.
Do you want to talk about, and I know Nico will as well, about whether or not the court made an error because the two photographs that are allegedly in contrast to each other, in contradiction to each other, were introduced at the same EBT, and therefore people at the EBT, the lawyers there, could have asked, how do you explain this discrepancy, Ms. Reyes?
That's correct, Your Honor.
So then it's not a feigned issue. In other words, it's not like where someone puts in an affidavit after saying X at a EBT, and in the affidavit they say not X. It's not that. It's not that situation. So how is this a feigned issue?
I believe it's a feigned issue because the photograph that was shown, the second photograph, Exhibit D, with the red Post-it note, plaintiff testified that she didn't know who placed the Post-it note there. She did testify that that was the hole. The hole was in a
The whole Post-it thing was a mystery to me. That's like leading. It's like a leading question to have a Post-it on a photograph. Do you know, can you tell me, because I wasn't able to discern, how did that happen?
I don't know.
No one knows who put the Post-it on pointing to the defect, the alleged defect.
All we know is plaintiff didn't place it there herself.
Yeah.
Who placed it there, we don't know.
What difference does that make? I mean, who cares who placed that Post-it note on that photograph?
Well, I believe it goes
Plenty of times, it's normal, of course, for a photograph or a video to come into evidence that was taken by someone other than the witness or party who's going to testify to what's depicted in that photo or video. What's important is the witness testifies that, yes, that video or that photo is the same or substantially similar to the condition as I recall it. So I think as Judge Moulton said, what difference does it make who placed that arrow and that it's there at all? She testified to what she testified to.
Yeah, I believe that the issue is that in the other photograph, Exhibit H, where she circled, initialed where she fell, and prior to being shown the photographs, she testified that as she walked into the street from the sidewalk, her left foot got caught in a hole, and she was in the parking lane, and there was a car directly to her right that she attempted to grab onto to brace her fall. In the photograph that's marked as Exhibit D, that she was later shown, that photograph, that hole is nowhere near.
Right, but
the
counsel,
first
she was
location.
still shown that photograph. She still identified that as the defect, and she was shown that photograph presumably by defense.
That's correct. But the question is if plaintiff knew that hole was the same hole that she's testifying to earlier. And
Well, was she asked that at the deposition?
I don't believe she was, but
Okay,
she
so
always
we're
has.
stuck with the deposition as it is, right?
Correct, but plaintiff had the opportunity to go back and correct the circle that she had circled.
Why would she go back and correct anything if she's already been shown a photograph where the defect is and identified that as a defect?
Because the defects, the first hole that she identified was in nowhere near, or it was 3 to 4 feet away from the defect that was in the second photograph that was shown.
Why would the plaintiff have to go back and correct that if she's being deposed by defense and defense is showing her photos of both areas of defect that she then identifies as the place where she fell?
Because the two photographs are in direct contradiction to each other, and I believe that, based on the testimony that was earlier, testified to by the plaintiff, the first photograph in the circle that she made is more accurate to the location of the accident because of the relation
Counsel,
of the car.
Don't these questions really ask for a trier of fact as in a jury to decide? Because it sounds like you're arguing against yourself. You're saying the plaintiff is incredible, and you're asking the court to make a determination as to that credibility. That's a function that normally lies within the purview of a jury, right?
I agree. If the court was to agree that the second photograph was the location of the accident, plaintiff has provided no expert testimony, measurements,
Well, it's not if
anything
the
to
court
prove
was,
that, what
the
caused
issue's
that.
not really about whether the court agrees that that's the location of the accident, but really that it raises a question of fact as to where the accident occurred. Because she identified both places as where the accident occurred, and she wasn't pressed about that at her deposition.
I understand. I just believe that the circling and the initialing and the specificity that she made in regards to her prior testimony about the relation of the car and the parking lane, that I think pinpoints the exact location where her accident occurred.
Thank you, counsel.
Thank you.
Time to rebuttal.
Good afternoon, Your Honors. Kenneth Gorman for the plaintiff, respondent appellant. This isn't a feigned issue of fact case. I mean,
Does the plaintiff have to go back and correct her deposition based on identifying two distinct places as a place of the alleged defect?
the plaintiff's a layperson. She's being deposed. I mean, she would. I mean, if she points to the defect in a subsequent picture, it wouldn't occur to her, unless she was told that her case would be dismissed if she didn't change her testimony or correct the defect. No, she shouldn't. There's no. It just goes to the it doesn't go to the admissibility. It goes to the weight of the
But
evidence.
you say that she basically adopts Exhibit D, right?
Correct.
Okay. You say that's a clarification, quote unquote, of her prior testimony. Isn't it a contradiction of her prior testimony at the EBT?
I don't think so. I mean, this is several minutes later. It's 10 pages after she was shown the Google photo. I mean, when she's shown Exhibit D at page 333 of the record, she points to the defect. I mean,
You also said, though, that she tried to grab onto a parked car in the parking lane, which was not a double parked car, and that's consistent with Exhibit H more than it would be with Exhibit D. Wouldn't you concede that?
I couldn't go one way or the other. I mean, I think this all goes to her credibility. And I mean, I think because she points to the whole, and I mean, she identified the defect. And I just want to point something out. The case of Schechter versus City of New York that Verizon cites to in its brief at page 8 actually supports the plaintiff's position. I mean, Verizon's brief discusses Empire City Subway, who established that the plaintiff's accident in that case happened nowhere near the conduit pipes that it installed. But what it doesn't discuss is the defendant Petrocelli Electric, who made the same arguments that Verizon, Nico, and the other defendant make in this case. They basically said that the plaintiff, in that case, her testimony was incredible because she testified that she fell, I think, 3 to 4 feet from where Petrocelli did work. And this court said that this court reinstated plaintiff's complaint against Petrocelli.
Counsel, does the record indicate anywhere that Exhibit D, the photograph depicted in Exhibit D, was used anywhere else so as to account for the tab that's placed on the photo?
Not that I'm aware of. I can't answer that question.
Right, because it was defense counsels who showed her that photograph
Correct.
at the deposition,
Yeah,
right?
I mean, it could have been defense. It could have been anybody who put that tab there. But the bottom line is that she identified the defect. She identified the location. That photo basically clarified her prior testimony. It was in the same EBT. There's no feigned issue of fact. If there's any other questions, I'll just rest on my brief. Thank you very much.
Thank you, counsel. Please.
Good afternoon. May it please the court, Amory Minor on behalf of the defendant respondent, Nico Asphalt Paving, Inc. Your Honors, Nico established a prima facie case that Nico did not create or contribute to the alleged hole that caused plaintiff's fall.
Except, what about if Exhibit D is the correct depiction? It's very adjacent to it's really next to inches away from the hole as demarcated by the tar.
There's a couple issues in that, and I know that some of these issues have already been addressed. We are relying on the Exhibit H, the photographed that...
No, I'm asking you to think about the other exhibit
I
for now.
understand. So focusing then on Exhibit D, Plaintiff conceded during her deposition that some of those additional photographs some were taken by her and some were taken by somebody else, presumably plaintiff's counsel. They were also taken at least a week after the alleged fall.
Counsel, I hate to sound like a broken record here. Does it matter who took the photographs when, in fact, defense counsel chose to take those photographs out at the deposition and show them to her?
It doesn't matter in the sense that she identified the location of her fall through the marked Exhibit H, and then she discussed the hole that she was observing in what was Exhibit D. What is, as your honors were indicating earlier, what's very important is to note that when she testified, when she was shown Exhibit H, she talked about how she was walking from right to left across the photograph, and she fell right by the parked car that's shown in the photograph. She described with explicit detail about how she fell right behind the brake light of that parked car. She had to lean on that car when she fell. The fact that she then discusses another hole that's shown in a different photograph taken after the fact by somebody else is not at issue here. So she's not, and I think it's important to note that we're here because plaintiff is not disputing the fact that the location of this alleged hole that she identified in Exhibit H is not where Nico performed its work. If that wasn't an issue, or excuse me, if plaintiff wasn't conceding that issue, that that's not, that hole, that identification of the location is not where Nico performed work, we wouldn't be here. So again, it's just the photos that were shown in Exhibit D again, during the time of her deposition, she didn't use that opportunity to correct the record when she was identifying.
She's not deposing herself.
I understand.
Defense counsel is deposing her. All I'm hearing you say is that you have a bunch of great fodder for cross-examination. That's all I'm hearing.
I understand your position, but I think it's also important to note that, as counsel pointed out, it was short in time from showing these Exhibit Ds after she was shown Exhibit H. She had every opportunity to look at these additional photographs and say, this actually refreshes my recollection as to where I actually fell. Or her counsel might have stepped in and added some additional questions at the end of her deposition to help clarify the record, as counsel for one's client is supposed to do.
Why would plaintiff's counsel clarify the record when defense counsel has shown her the defect and she's identified the defect with the post-it on it as where she fell? What clarification is needed?
The clarification would be that marked Exhibit H with the pen.
I saw them before.
I understand. But I'm just trying to emphasize the point. The plaintiff took pen to paper to mark where the hole was. That was never clarified during the course of her deposition by any of the attorneys, including her own.
Was she asked to clarify it by defense counsel?
There was no, as my reading of the transcript and recollection, there was no explicit question to the plaintiff of, well, would you like to change your testimony as
well, no, the clarification is we've shown you this photograph and you said that you fell here. And now that we've shown you this photograph with this handy dandy post-it on it, you said you fell here. Which one was it?
My recollection is there's no specific question to that effect. Again,
but then we're stuck, aren't we?
I'm sorry?
Aren't we stuck? I mean, as appellate judges, do we make findings of credibility?
No, Your Honor. In fact,
as to weight, I mean, can anyone even determine what the weight of the evidence, what should be accorded here?
I would ask this court to look at a prior ruling of yours of Phillips versus Bronx Lebanon Hospital, where there was a very similar situation where the court stated that while issues of fact and credibility may not ordinarily be determined on a motion for summary judgment, whereas here, the self-serving affidavit submitted by plaintiff in opposition clearly contradicts plaintiff's own deposition testimony and can only be considered to have been tailored to avoid the consequences of her earlier testimony. And with that, I would thank you.
If there are no further questions, we rest on the brief.
Okay, thank you, counsel.
Thank you.
Plaintiff, do you want to be heard?
Same thing. If there's no further questions, I'll rest on my brief.
Okay, very well. Thank you all.
Thank you.
AT&T Mobility Holdings v. Grupo Salinas. Okay, counsel, thank you.
May it please the court, Kenneth Caruso for the appellants. Under the Court of Appeals decision in Techniplex, control of the attorney-client privilege passes only to successor management, which stands in the shoes of prior management and attempts to run the pre-existing business and manage its affairs. Here, the receiver does not qualify as successor management and therefore does not get my client's attorney-client privilege.
Did the court there consider the precise issue we have before us, which is the extent to which, if any, a receiver may stand in the shoes for the purpose of discharging the receiver's obligations?
Techniplex did not involve a receiver. However, Techniplex adopted the U.S. Supreme Court decision in Weintraub, which was based squarely on a federal bankruptcy trustee, which is the exact analogy to an Article 52 or state law receiver. So I think the absence of a receivership issue in Techniplex is the proverbial difference without a distinction, because all the cases subsequently and prior in Weintraub are based on receivers or federal law equivalents. So it's undisputed that Justice Maisley did not transfer management powers to this receiver, and absent management powers, the privilege does not transfer. And
Does it matter that that Judge Maisley only permitted the receiver to waive the attorney, or I guess the transfer of the attorney-client privilege to the receiver was limited to the specified matters on which the receiver was going to attempt to effectuate a satisfaction of the judgment?
No,
it
sir.
wasn't a broad, encompassing waiver power.
That does not matter. That does not matter at all. So there's only a little bit of a violation of a sacred privilege. Okay, that's not the point. The point is that whether the order transferring the privilege for this much or that much should have taken place at all. And I suggest that the analysis begins and ends there.
So-
No transfer of management, no transfer of the privilege.
So are you saying that it's not so much a matter of the court's power to appoint a receiver so much as what authority the receiver was given?
Yes, assuming that this was a proper case for a receiver.
Well, we could go there too, because you keep coming back on appeals. I mean, the judgment was appealed, it was affirmed. The fine was appealed, and it was removed. And now you're here, no amount of the judgment, from what we understand, has been satisfied to date. And you're saying, even though technically speaking, in the eyes of the court, we are in abject noncompliance, you can't do anything here.
It's not that you can't do anything here, Your Honor. It's that it's not a situation where anything that my client did or failed to do warrants such a drastic remedy.
How do you characterize transfers of monies to Canada, and was it Mexico as well? Was
No,
it both?
all the transfers.
Only Canada?
All the transfers involved assets that were at all times outside of the state of New York. The transfer that I've used as an example involved the transfer of assets from Canada.
This court has already held that we have in personam jurisdiction over the defendants. Isn't that all that's necessary?
No, sir. When a court has in personam jurisdiction over a defendant, then the court has the power to direct the defendant to take money and put it into New York. But that's not what was at issue here. Here, the question is whether there's a court should transfer an attorney-client privilege based on disobedience of a court order. Let me get to that point too, because this case is unprecedented, not simply because of the lack of management powers.
Does it matter regarding the privilege that the companies are just holding companies?
I think not, because there's nothing magical or talismanic about a holding company. A holding company, my client, characterized as holding companies, it has assets, it has bank accounts, it has securities accounts, it buys and sells stock and other securities, it has auditors, it has financial statements.
And all of that all points to the receiver being able to obtain the monies from the judgment.
Well,
all of the things that you just named.
What I'm saying is that there does exist
management of my company, my clients, despite their status as holding companies. There does exist management, but it has never transferred to Mr. Fink his client in his capacity as receiver. Now, I'd like to turn to the other respect in which this case is completely unprecedented. No case, until this case, has ever transferred an attorney-client privilege based on disobedience of a court order. We have legislation on that topic. It's called the judiciary law, contempt. And the legislative judgment was that when somebody disobeys a court order, there can be contempt, and the sanction is fines or imprisonment. The judiciary law does not envision the transfer of an attorney-client privilege.
I know you're not suggesting that your client should be imprisoned, right?
Well, they have suggested that some of the, in related litigation, they have suggested imprisonment for some of the people affiliated with my client. But my point is that the remedy here conflicts with the legislative judgment in the judiciary law that the penalties for remedies for disobedience of a court order are fines and imprisonment, not the attorney-client privilege. There isn't a single case that has ever done that based on the disobedience of a court order. And that's a good reason for that, because the legislature never authorized it and authorized something else.
Thank you, counsel. You have time to rebuttal.
Good afternoon, Your Honors. Adam Abinson for AT&T. I'll be addressing the portion of the appeal challenging the appointment of the receiver, and the Receiver's Counsel, Mr. Fink, is here to address the question of the transfer of privilege.
He argues that by bringing proceedings in Mexico, you undermine to a degree the first factor in Hotel 71, in that you do have some means of collecting this outstanding judgment.
Your Honor, that question was resolved, among other cases, by this court's decision in Pala and by the Court of Appeals decision in Hotel 71. In Hotel 71, the court explained what it means to have an alternative remedy. It doesn't mean you can go to some other jurisdiction and try and effect some kind of process. The question is, are there sufficient liquid assets to satisfy judgment, in which case a company like AT&T can receive that liquid asset and make good on the judgment? Or are we dealing in illiquid assets, in which case AT&T, which is a phone company, is not positioned to do that? If these are foreign illiquid assets, neither is a New York sheriff. Hotel 71, I'm quoting it, says, a receivership has been held especially appropriate when the property interest involved is intangible, lacks a ready market, and presents nothing that a sheriff can work with at an auction. That is a direct hit. Now,
Electra is publicly traded, but SCT is not publicly traded, correct?
Actually, Electra has been taken off of the public trading. This was the incident in our briefing where the receiver showed up at a shareholder meeting of Electra where they were voting to pull it off the public exchange and privatize it. The other company,
Meaning
STP,
he did not get into.
The other company, STP, is private. These are the black letter example of the kind of assets that are appropriate for receivership. This talk of international comedy and should we go to abroad is a distraction, as it was held to be a distraction in Pala. Pala is this case. Pala is a case with an outstanding judgment, with a violation of a turnover order, with receivership instituted to try and collect funds that were in another country. If you substitute the name Pala for Grupo and the country Mexico for India, it is the same case. And what the court said in Pala is that the institution of a receivership to help secure assets in a foreign country, quote, does not offend considerations of comity. The entire logic of what counsel is talking about, and the court used the phrase abject noncompliance. These are tools in the trial court's tool bag to try and deal with a litigant that has now spent 2 years not paying a judgment, that has been held with this court's affirmance to be in contempt, and that is in contempt of the contempt order, because it certainly hasn't paid that amount.
Your adversary said that moving for contempt was your best option.
It hasn't gotten us the money, Your Honor. That's the point. The point is these are ongoing. It's an outstanding judgment that remains unpaid. AT&T needs help. That's what a receiver is for. That's why the court assigned it to this mission. This is, again, exactly what was authorized in Pala. As far as this notion that counsel doesn't seem to realize they are subject to New York jurisdiction. A court in New York does not have to defer to a hypothetical enforcement action in a foreign country. This court has already held that the New York court has personal jurisdiction over his clients.
What about the managerial authority issue?
Your Honor, respectfully, that's going to be the argument that
Thank you.
Receivers Counsel handles. But I'll conclude by saying that counsel, he didn't repeat an argument he had in his brief about how this court has discretion and it should exercise the discretion in his favor. If ever there was a appellant not deserving of an exercise of discretion, it would be this one. Violation of at least 3 court orders. Receivership is the standard remedy for this situation, precisely as it was in Pala, precisely as it was in Hotel 71, and we ask respectfully that the receivership be affirmed.
Thank you.
Good afternoon. Stephen Fink for the receiver. I join in Mr. Abenson's comments, and I'll focus on the privilege issue. And on that issue, what I think gets missed in Mr. Caruso's argument is the scope of CPLR 5228. And that provision gives extraordinarily broad discretion to the trial court to authorize the receiver to do any other acts designed to satisfy the judgment. Supreme Court here.
So you disagree with Mr. Caruso's argument that it's only within the court's jurisdiction to order that the receiver may obtain privileged documents if it's also, unless, can only do so if the receiver also has management authority.
I absolutely disagree with that, Your Honor. CPLR 5228 doesn't say anything like that, and the cases that Mr. Caruso relies on are dealing with an entirely different situation. What we have here is an order from Supreme Court amending the order appointing my client that says you may have control over these particular categories of privileged documents. Mr. Caruso relies on the Court of Appeals in Technoplex, and Technoplex in turn talks about the United States Supreme Court decision in Weintraub. Those cases dealt with a different question, nothing to do with CPLR 5228. The question was whether a successor by merger, in the case of Technoplex, or a Chapter 7 trustee, in the case of Weintraub, should be presumed by operation of law to have control of the privilege, because there was no answer. There was no order granting access to the privilege like we have here. In fact, the Supreme Court specifically says in Weintraub that the reason it develops this management control analysis that Mr. Caruso relies on is because the bankruptcy code didn't provide any guidance. So it needed to come up with some sort of test, and that's what they did. So this management control analysis has nothing to do with the issue before this court. But even if it did, we believe that we win there as well. And the reason is, Mr. Caruso says, well, these are holding companies, but these are shell companies, not in some sort of abstract sense. They don't even have phone numbers. They don't have any employees. They don't have any officers. They don't have any directors. There's one fellow, Mr. Medina, who we're told is responsible to oversee these entities. Search the record in vain. You will not find any example of Mr. Medina doing anything having to do with these companies.
Sir, am I correct that Judge Masley, in granting your motion, the clarification motion vis-a-vis the powers of the receiver, granted that motion to the extent that it transferred the attorney-client privilege and the associated waiver powers only coterminous with the communications that were relevant to the defendant's assets?
That's correct, Your Honor, and that's exactly what Chief Judge Kaye did in Technoplex. She said the privilege goes here for some purposes, and it goes there for other purposes. And it all ties back to CPLR 5228, that language which says that the court is authorized to give the receiver the ability to do things designed to satisfy the judgment. And the categories of information that my client was given access to are categories that he needs in order to seek the assets, to find out where they are, to marshal them, that he needs to determine if there was misconduct by third parties.
Assume with me for a second, a hypothetical, that the receiver seeks documents or other information that the defendants, the judgment debtors feel are outside the scope of the receiver's responsibilities? Would they have some sort of procedural remedy to invoke the attorney-client privilege?
They don't at this point. That was the subject of the argument in front of the court and the crowd, and there were 2 lengthy hearings.
Right, but if, when the rubber meets the road and these documents and this information is sought by the receiver, if in fact we agree with you, and then the judgment debtors feel that information or documents are being sought that are outside the scope of the receiver's powers by virtue of Judge Masley's order, to the extent, again, we agree with you, would they have some sort of remedy to challenge that disclosure?
To be clear, Your Honor, documents started being produced in April, and that's continued. The discussion around the question you're asking happened at the conference when those 6 categories of information were debated and were defined by the court. Now, I can tell you that Paul Weiss certainly is being, cautious about what it produces, and if they believe anything's beyond the scope, they're certainly fully capable and have been pushing back, but not Mr. Caruso at this point. The one other, and I know I have my red light, there was one other point I wanted to make.
Actually, Justice Gonzalez has a question for you.
Yes.
So to the extent that $826 million in STP stock is sought, and that amount exceeds the amount of the judgment, how do you explain that, or how do you justify that?
Certainly, Your Honor, and that's part of the statutory scheme, which provides that assets in excess of the amount of the judgment can be made part of the receivership, and then once the receiver liquidates whatever he's actually able to get his hands on, anything in excess of the amount of the judgment has to get turned back over to the judgment debtor. So we don't get to keep more. And I'll also say we don't really know if that is really worth $826 million and what we might be able to liquidate it for. Part of the reason why a receiver was necessary here is because these are illiquid assets, and it's not something that the sheriff can just go sell at a regular, it's going to be a complicated process to deal with those, and that's why somebody with expertise in doing that was required. I did have one other point I was going to make, but I know my red light's been on, and
30 seconds, counsel.
30 seconds, thank you. Mr. Caruso made the argument that somehow this was a contempt sanction in disguise. There's nothing in the record to suggest that. My client hasn't been able to get the information he needs from anywhere else. He reached out to all kinds of people, got stonewalled. Whose fault it just doesn't matter. CPLR 5228 again says that the court can authorize the receiver to do things designed to satisfy the judgment. That's exactly what this order is. Thank you.
Thank you, counsel.
Let me begin where counsel left off. I do not contend that this is contempt in disguise. My point is that a judicial branch ordering the turnover or transfer of an attorney-client privilege based on the disobedience of a court order conflicts with the judgment of the legislative branch that there are certain statutory punishments for disobedience of a court order, and they include fines or imprisonment for contempt. They do not include the transfer of an attorney-client privilege. That's my point.
So essentially, you're acknowledging that your client has violated court orders but is nonetheless entitled to a remedy here, right?
May I restate that? My position is that despite failure to pay the judgment, the receiver is not entitled to the remedy of getting my client's attorney-client privilege.
But the receiver is entitled to whatever steps necessary to be able to find the assets and get those assets. That's what the provision is for.
Of course, but there are limits. There are limits on the receiver's powers and on the discretion that the appointing court had. And I would suggest to you that one of the sacred bedrock limits is attorney-client privilege.
And the judge considered that by tailoring the order to those documents that deal specifically to receiving assets.
Okay. But I'll go back to what I said early on. You're not a little bit pregnant. This is not a little bit of a violation. Either you transfer the attorney-client privilege or you don't. And here the judge did. Now it doesn't matter whether there was only a little bit of intrusion on that, what I keep calling sacred privilege, rather than some big intrusion. The point is there should not be any intrusion at all because it doesn't
So
qualify.
what you're saying is that there is no time where a receiver can be entitled to attorney-client documents at all, even if to receive payments that have not been paid?
Not unless that receiver has management powers. Every single case holds that. Weintraub, Technoplex, and all the other lower court cases. The receiver can get the privilege if he has management powers, but he does not. May I have 30 additional seconds?
30 minutes, 30 seconds.
Very quickly on the threshold question of 30 minutes. Thank you, Your Honor. Going to the point one of my brief, the appointment of a receiver in the first place. AT&T has taken matters into its own hands now. It started its own recognition proceeding in Mexico. It has that alternative remedy. It did that without the receiver. The receivership will not increase the likelihood of satisfaction of the judgment. Neither one, AT&T nor the receiver, has power in Mexico. The New York order doesn't have any force in Mexico unless they seek recognition. The receiver's never done that. AT&T has. AT&T has a head start.
Counsel, just hypothetically, although the hypothetical matches the facts of this case, if someone transfers $5 million to Canada within 3 days of the judgment, doesn't that just prima facie say, let's get a receiver here before that happens again?
That didn't happen. The transfers were of money always out of New York. I would agree with you if there was X million of dollars in New York and it was transferred within days of the judgment to a foreign country. I would totally agree with you. But here you have a situation where the assets were never in the state of New York.
But those were assets that could have been used to satisfy the judgment, regardless of where they were, right?
No. The New York court has no power over those assets.
Thank you, counsel.
Thank you.
Thank you all. You have further question? Thank you. Hereford Insurance v. 21st Century.
Good afternoon. May it please the court. My name is Jason Tenenbaum. Sorry, it's a no-fault case and nowhere near as interesting as the last one, but to cut to the chase here, it actually is an interesting issue in the realm of, is the failure to subscribe and return an EO transcript, is it a breach of a condition preceding to coverage? Is it more akin to an...
Or is it a condition preceding to the obligation to perform under the insurance policy?
Exactly.
And you take the latter, but haven't we said the former?
Well, if it's a condition preceding to the performance, then that would therefore mean that it is a precludable defense under New York law. You see, the thing as I understand it here is that these people, they showed up to their examinations under oath. They testified truthfully. Various arbitrators at evidentiary hearings found
We know that you said frequently in your briefs that they were found to have been truthful. I didn't see anything on the record that supported that.
There were
In the record.
There were arbitration awards. I'm not sure.
Those weren't in the record, were they?
I thought they would. Again, I inherited this case, so I did believe they were there. But be it as it may, putting that aside here, and again, we know that's true because they only moved for summary judgment on the issue of the return of the EUO. Indeed, if there were findings that these people at arbitration hearings was a staged accident, they would have obviously moved for summary judgment on the issue. I think the broader issue, though, putting all that aside, is I'm not asking the court to revisit the 2009 Unitron case. What I'm asking the court to do is to say, listen, if someone does show up for their examinations under oath, does give testimony, they've at least triggered coverage. And then the question is whether or not, there was a violation of what's more akin to an exclusion, as Justice Mazanet Daniels and every other appellate division has said here. So I do believe that really is the focus of, I believe, what my argument is. And I think based on the weight of the evidence, the fact that, again, they showed up for the EUOs, that this should be looked at under that prism. The prism is whether or not there was a timely disclaimer, and that's a precludable defense. This court in all of New York found that. And I myself am having a hard time trying to differentiate the directions this court goes on some of the cases.
Counsel, I have a somewhat different question. You rely a lot on the fact that ultimately you you produced copies of the deposition transcript, which you claimed were subscribed by the parties. I didn't see anything that authenticated the signatures. There's nothing showing that you received it from claimant's counsel. There's nothing to show that claimants signed it in front of anybody who identified them. So I'm curious how you authenticate that, the
I believe it
alleged
was signed,
subscription.
they should have been, if I'm not mistaken, Your Honor, they were signed and otherwise notarized. I do believe, which would,
But that's not self-authenticating, counsel.
it's signed and,
Right, that's not that doesn't constitute authentication.
well, Your Honor, if an affidavit, from my understanding, is it's sworn to the penalties of perjury, it does carry imprisonment if it's a lie. Why would, I mean, and I don't mean to ask the question of the panel, but if someone produces a document that is subscribed, that is sworn under penalties of perjury, why would that not, meet the standard of a signed and otherwise subscribed document? And maybe I'm missing the point of subscribed, but my understanding is if someone comes to an office and it gets signed and it gets notarized, it's a valid document. We don't even use affidavits anymore after 2024 under the 2106 amendments. But the point of the matter is it was signed and it was otherwise sworn to and was produced in opposition. I'm not, I don't understand why that would not at the very least raise an issue of fact as to that particular issue. You look puzzled, but I just, in my mind and the way I see the facts for that, it was signed, it was sworn, it was produced to the court. I don't understand what additional foundation I would need for an affidavit, which is essentially what an EUO is or an EBT. It's a sworn to statement, i.e. an affidavit. The other issue, Your Honor, is that I do believe under various precedent that even putting all that aside, the burden is more of a Thrasher type burden, and I do believe I rely on the Simmons v. State Farm case, Fourth Department case, which under a similar vocational aspect, I see I'm running out of time here, I'll just finish my thought here, under a similar vocational aspect of the no-fault regulation, the Fourth Department held that a Thrasher type willful disobedience showing was not made. And again, in light of the fact that these people showed up for their EUO, it would only make sense that the burden to void coverage, using the court's language, is that there should be willful disavowal, using both the Simmons case and in the IK medical case of the appellate term, they kind of suggested.
Thank you, counsel. You have time for rebuttal.
Thank you.
May it please the court. Good afternoon. Victoria Tarasova for Hereford Insurance Company, the respondent. As an initial matter, we do note in our respondent's brief that the Thrasher argument is made for the first time on appeal. It was not raised in the moving papers below. In addition, the moving papers below also did not ask the courts to treat the EUO subscription defense as a precludable defense. The 11 New York CRR 65 1.1 has in the same sentence that in order to, that as a condition precedent to coverage, an eligible injured person shall, as may reasonably be required, submit to examinations under oath by any person named by the company and subscribe the same. There's no intermediate language in between the requirement for appearance in an EUO and subscribing the EUO transcript to relieve that person of subscribing their transcript. We have two claimants here who they themselves have actually defaulted in this declaratory judgment action, and the lower court issued an order against these two claimants saying that they breached the condition precedent by failing to subscribe their EUO transcripts. But in their transcripts, they were advised that they will be receiving copies and that they need to subscribe them and return them to the company. Here, this court has already issued at least 3 cases specifically stating that the failure to subscribe an EUO transcript is a violation of a condition precedent to coverage, regardless of if there was a denial of the claim. We also note that the inherent nature of the provision is that the EUO first has to occur before the carrier can ask the claimant to subscribe the transcript. So appellant's arguments regarding the timeliness of the requests, should they be requested within 30 days of receipt of a claim form? Here, there's a distinction here between the carrier asking the claimants to provide some sort of document verification and subscribe a transcript, because the carrier itself first needs to receive the transcript before he can send them to the claimants for subscription. The lower court properly found that the EO transcripts, one, they're dated June 7, 2024, which is 3 years after this action was, actually 2 years after this action was commenced, and about 3 years after the EO subscription request went out. The lower court found that presenting them on June 7, 2024 is too late, and they were unauthenticated. There was no affidavit from either of the claimants attesting that this is my transcript. Yes, I signed it on June 7, 2024. There's also, even in the affirmation from counsel, who was a counsel for other providers in the action, explaining how did it come about that they obtained those transcripts and why are they presenting them in 2024? Why weren't they presented earlier? So we respectfully ask the court to affirm the lower court's decisions. And also, we do know that even though we object to the Thrasher argument, we do argue in our brief that the case law that appellant cites, such as American States v. Huff and Countrywide v. Gotham, all dealt with situations where somebody appeared at an EUO, and then the counsel at the EUO started going back and forth about, are questions asked at the EUO proper? This is not the case here. Here, it was clearly about, did these people sign the transcript timely? And we argue that the lower court properly denied the moving party's motion to dismiss.
Thank you, counsel.
Thank you.
I would just note the All of New York case that this court issued, in which when an individual appeared for the EUO, this court did deny a summary judgment based upon a provider's failure to appear because there was no timely denial. I do believe this is an issue of an exclusion or a condition preceding to the performance, not a condition preceding to coverage. With that, I have nothing else. Thank you, everyone.
Thank you, counsel. Thank you both. Filipanta v. Hudson, 888.
Good afternoon. May it please the court. Jonathan D. Moran for the plaintiff appellant. Your Honors, I respectfully submit that the trial court erred in denying plaintiff's motion for summary judgment on his Labor Law 240 sub 1 cause of action. The trial court ruled that the plaintiff had failed to meet his prima facie burden, primarily citing to the fact that there had not been a prior incident involving the A-frame ladder from which he was working at the time of the accident. The trial court also cited to a second department case called Joseph. I submit, Your Honors, that the record at bar is unrefuted, that while performing a covered activity, the ladder suddenly moved and tilted over, creating a presumption that the ladder was inadequately secured for the purpose of—
Counsel,
Yes,
two
sir.
things. I'll just start with Mr. Barbera, Diego Barbera's testimony that the ladder was standing when he entered the room soon after the accident, and the plaintiff testified that the ladder fell over with him. Is that important?
I would submit that it is not dispositive in any way or even relevant to the analysis at bar because, number one, Mr. Barbera came, we don't know how long after the accident, but there is an undisputed fact that there were other people in the room. Mr. Barbera does not say whether or not he asked anybody, hey, was this the way the ladder was when the accident occurred? No one asks if, no, he doesn't say that anyone moved the ladder or not, so it's really speculation that that was the way the ladder was immediately after the accident or at the time of the happening.
Is it your argument that even if the ladder was standing at the time of the accident, it doesn't matter because the plaintiff said it shifted in some way that caused him to fall?
Correct, yes.
Counsel, the motion court relied on the second department Joseph case. How do you distinguish that case from the facts here?
Sure. So in Joseph, the ruling from the second department was that the mere language that the ladder shook without more language from the plaintiff connecting the shaking to the fall did not create a prima facie showing. So I would submit as an initial matter that that holding is not in keeping with the department case law. However, even if one were to assume that this court would adopt that reasoning, here this case is completely distinguishable because here not only did he say that the ladder shook, he said it tilted over and completely fell over. He also connected the movement, even if one were to assume that it merely shook and did not fall all the way over, that the movement of the ladder is what caused him to fall. So I think for all those reasons, the holding in Joseph is not only inconsistent with this department's case law, but is not factually, I would say it's factually an opposite to the case at bar.
What role, if any, should the medical record play in our analysis?
Sure. So I would submit as an initial matter that the one uncertified page from the medical record was not submitted in admissible form and should not have been considered by the trial court, were the trial court to have proceeded past the prima facie showing ruling. However, even were one to consider the statement contained in the hospital, let me backtrack for one more minute. The hospital record was uncertified, and there was also no indication that the translation provided by the hospital staff was competent, objective, and accurate, as was required under Biancaneto and Sanchez v. 1 Burgess Road. However, even if one were to take that statement at face value, that he slipped and fell, I would cite to Lynn v. 100 Wall Street, which that is not contradictory to his statement that the movement of the ladder caused him to fall. In Lynn, he gave a statement to the supervisor, I slipped and fell, or I lost my balance and fell. It's one of those. And the First Department held that the more detailed testimony that fleshed out what caused the accident was that the loss of balance that was caused, precipitated by movement of the ladder. So even if you consider, Your Honors, the hospital record, it is not contradictory to anything that the plaintiff testified to. Unless the court has any other questions, I'd be happy to rest on my briefs.
I think we're good, counsel. Thank you.
Thank you very much.
You have time? Oh, you don't have time in rebuttal, actually. You didn't ask for it, so, okay.
Good afternoon, Marina Barcy for the respondent, USA Interiors.
Just picking up on that last thread about the medical records, I mean, is it really inconsistent for him to say, I lost my balance? It could also be that he lost his balance because the ladder was not adequate to the task.
It certainly could, but we don't know. All plaintiff testified to at his deposition was that the ladder moved and he fell, and then he was asked, well, how did the ladder fall? And at some point he said it fell to the left, and at one point he said it fell to the right, and then he went to the hospital, and the hospital records say that he lost his balance and fell off a specific rung of the ladder. These are all plaintiff's statements that are inconsistent, and how the accident occurs, if the ladder moves and he lost his balance and fell, certainly that could be a labor law 240 case, but if he simply lost his balance and fell off the ladder without any movement from the ladder, then there's no inadequate safety device, and it's
That's
not a
not
labor
what
law
we
case.
have here. We have him saying that the ladder shook and he fell.
And then we have records from not only the hospital, but a supervisor, his supervisor, who testified that, or reported that plaintiff told him he just simply fell off the ladder. We don't know whether the ladder moved or not, and plaintiff's credibility is at issue for the trier fact.
Recent case law from this department where on the one hand you have information that the plaintiff lost their balance, and then on the other hand also testimony that the ladder shook, and we've held that to not be inconsistent testimony, but rather clarified, consistent testimony sufficient to sustain a labor law claim.
And this court has also held the opposite, where if the...
When did we hold the opposite?
In Albino versus 221 to 223 West 82 Owners Corp., this court affirmed that a triable issue of fact existed as to whether plaintiff's fall was caused by the movement of a scaffold or whether the plaintiff simply lost his foot, and we submit that the same question exists here.
You seem to be asking us to look to the medical records. How do we deal with the fact that that's not certified? Why should we consider that?
The medical records are admissible in their form for considering plaintiff's credibility on summary judgment. The medical records are business records that
But we don't know their business records, and they're not certified. Why should we consider? You seem to be skipping ahead.
Sure. Plaintiff also had a chance to review the medical records and was asked whether or not they were accurate, and he testified that they were accurate.
But that's not up to him. You're submitting them as a matter of law, as an admissible document. Why should we consider them admissible?
The standard for summary judgment is less stringent than it is when you're at trial, and you can consider something that would not be admissible at trial for summary judgment purposes when it is not the only evidence that we have. And it's not the only evidence that we have here of plaintiff's inconsistent statements. We also have the construction superintendent that you referenced earlier, who says the ladder is standing upright only minutes after the accident occurs.
The ladder falling is not a prerequisite to a labor law violation, right?
Correct. There's just inconsistencies that the medical records, to your point us to, which add questions. And if you tally up all the questions as the non-moving party, given all the inferences that could be made, there are plenty of credibility issues for a jury to determine how this accident occurred that are inappropriate for summary judgment, which the lower court found and we're asking you to affirm. Thank you.
Thank you, counsel. Thank you both. People versus Raymond Clarita. Justice Michael is recused in this matter. Please.
Thank you. Good afternoon, and may it please the court. Jane Merrill for Appellant Raymond Clarita. As the Court of Appeals recently reiterated in People v. Salas, Criminal Procedure Law 440-30 subsection 4 permits the summary denial of a 440-10 motion in only 4 enumerated circumstances. The reason for these limited circumstances, this court has explained, is because the question at the motion stage is only whether a defendant has made sufficient allegations to warrant a hearing, not whether the defendant has satisfied his burden of proof. The 440-30 pleading requirements are merely meant to weed out frivolous claims. This was not a frivolous claim, and none of those circumstances applies here. At minimum, therefore, this case should be remitted for a hearing on Mr. Clarita's 440-10 motion.
So here, there's not really any question about the defendant's, the identification of the defendant or the actions of the defendant. And so I don't think, I mean, you can correct me if I'm wrong, but just let me take that as a premise.
Yes.
So therefore, defense counsel had to deal with mens rea.
Correct.
And so he tried to deal with mens rea by one thing that was not a particularly strong argument, but what else was there aside from the alcohol argument? And is the alcohol argument also part of a larger mens rea argument that he did make?
Your Honor, certainly there was a hard case to make, but that's based on a case that wasn't investigated, a case that was not tested really through the adversarial system when there was no investigation behind that defense. So the record that we have here does not reflect the meaningful representation that we rely on to determine whether a defense was meaningful.
I don't understand. What was not investigated?
Yes, Your Honor. Counsel put forward time and time and time and time again evidence that Mr. Clarita was drinking alcohol that night.
Right, right.
And certainly that was corroborated, but entering that evidence into the record without any ability to make out an intoxication defense is a huge problem. And there was no investigation that supported that Mr. Clarita was intoxicated here. So what was uninvestigated was an intoxication defense. And again, these questions are reasonable questions. The nature of the proof, what specifically was uninvestigated. These are questions that are suitable for a hearing.
Well, you had Miss Bolden, right?
Yes.
And Miss Bolden, I think maybe this is what you're referring to with corroboration. She was able to at least corroborate, or not corroborate, but testify to the fact he did have 2 or 3 shots of Hennessy. Didn't this give at least defense counsel some good faith basis to argue to the jury, not get an intoxication charge in defense, but at least make a good faith argument that there was impairment here and hope to gain some traction on what was a difficult case to defend?
No, Your Honor. Presenting evidence of intoxication, presenting evidence of drinking without evidence of intoxication makes out, or certainly helps establish intent, not undermine it. So while Ms. Bolden did testify to that, without that legal foundation of what constituted intoxication, which counsel did not appear to have in any meaningful way, talking about his own experience with the brown liquors, that was exceedingly harmful. And again, these are really questions for a hearing court to sort out, whether this was part of a defense theory, whether that defense theory was adequately investigated. These simply don't fall into the 4 categories of 440-30 that are the only grounds for a motion court to deny this sort of motion on the papers.
What about lack of intent? Not as to intoxication.
Yes, Your Honor.
But as to the situation with which the defendant was confronted.
Certainly.
Relative to the father of his girlfriend's child.
Certainly, Your Honor, my adversary has put forward some instances of elements of the evidence that could go towards intent. But critically, counsel didn't make those arguments. So the fact, which I think you're getting at, that may have amounted to an argument about intent, that another argument about intent was possible, is exactly the sort of post hoc rationalization of a trial theory that is unsupportable without adequate investigation having been done, and simply doesn't reflect the meaningful assistance of counsel. And here, there are those threads. I can't deny that there are those quotes in the record. This record is truly bizarre. This doesn't meet meaningful representation standards when you have the counsel calling the jurors grand to him when he's testifying essentially about his own experiences with alcohol. Thank you. I
You have time
will
to
address the
rebuttal,
remaining
counsel.
points.
Thank you.
May it please the court, Noah Shamoy for the people. From its inquiries, I see that this court understands the issue of prejudice very well, so I will address the issue of performance, since that is the focus of the defense here. Counsel is claiming the intoxication defense was not investigated and cites to 440-30. We cite to 440-34B. Where is the record addressing the investigation? We're missing 2 sworn statements in this case. The 2 people who could actually speak to it, the defendant and his attorney. We have statements from all sorts of other individuals, sworn, who have no relevant testimony to give, but the 2 statements you would expect that are required under 440-34B are nowhere to be found in the record below. Well, that's more than important. That's essential, because the defense points out on page 7 of the reply that under Strickland, citing pages 690 to 691 of the decision, they say the counsel's decision to pursue an intoxication defense, if it's based on Mr. Claritta's say-so alone, was unreasonable and ineffective under Strickland. But the very next paragraph of Strickland says that's wrong. Okay? On page 691, the paragraph after the paragraph defense counsel quotes, it says, counsel's actions are usually based quite properly on information supplied by the defendant. What investigation decisions are reasonable depends critically on such information. When the facts that support a certain potential line of defense are generally known to counsel because of what the defendant has said, the need for further investigation may be considerably diminished or eliminated altogether. That is an express statement from the Supreme Court of the United States saying, you need to know what the 2 of them discussed. And that is the one thing we're missing here, because that's the one witness that we believe, based on the record as presented, was not presented below, which is Raymond himself did not take the stand. That's the one question we couldn't answer from the brief, but we do have a potential reason, which unfortunately is not in the brief, but it is in the record, which I also want to bring to the court's attention, which is on pages 622 to 25 of the record. In the middle of the defense case, their first witness was on the stand. Defense counsel already said he had 2 witnesses he was intending to present by that point. His witness is on the stand. They take a break between the direct and cross. At that time, what happens? The court says that if a witness takes the stand now to fill in this one gap of time between 9 p.m. and midnight, and testifies to the timing and number of drinks that Clarita had that night, which the court suggests would likely be defendant, then the people would have the right to present a rebuttal case in that situation that would allow them a limited rebuttal to disprove that evidence with evidence of his manner and demeanor from whatever witnesses that we had. The defense, unsurprisingly, mere minutes later, after their first witness stepped down, rested rather than call its second anticipated witness, because the court had just issued an order saying, fill in the gap, the people get to be the last ones to be heard by the jury.
That's a fair point, but does that really undercut your friend's argument that what the deficiency here was inadequate investigation, and had an inadequate investigation been undertaken, perhaps a very strong, potent intoxication defense could have been mustered? And,
Well, so
which
it's actually on those very pages that I discussed, which is the court discussing, I believe it's People v. Gaines, which is the Court of Appeals decision, which it discusses it in terms of who would be the likely witness, and that it would be the defendant, because who else would know how many drinks he had between 9 p.m. and midnight, and what effect it had on him. And that's the witness that it does appear he was anticipating to call. Having said that, he did not lock himself into a defense in opening. And that was originally the primary argument the defense was making, which is that the intoxication defense, as presented in opening, locked him so he had to present one. In reality, it was one presentation of an intent defense that he was not going to abandon. And in fact, on page 671 of the record, the court even says outright, you will absolutely have the right to present whatever intoxication material you want to the jury on summation, even without a charge. So counsel knew, no matter whether he got the instruction or not, he was anticipating presenting intoxication to the jury on summation. It was just a question of how much he would get to present and how it would go along with this intent defense.
Thank you, counsel.
Thank you, Your Honor.
Your Honors, this demonstrates perfectly why a hearing was necessary and called for. The purpose of a 44010 motion to satisfy the need for a hearing is, again, not to satisfy the burden of proof, but merely to make sufficient allegations. And 44030 sub B is absolutely satisfied here. 44030 subsection 4B says the motion is based upon the existence or occurrence of facts, and the moving papers do not contain sworn allegations substantiating or tending to substantiate all the essential facts. Certainly, Mr. Clarita's testimony might be something that, the absence of which might be something that a judge at a hearing could weigh in finding that the burden hadn't been satisfied. But at the motion stage, the affidavits that we had here from Mr. Byrd, from Ms. Bolden, all of those do tend to substantiate the allegation here, which was that counsel did not conduct an adequate investigation. Was that satisfied? This court doesn't need to decide that. This court needs to decide whether or not the 4 enumerated subsections of 44030 are satisfied. And here, none of those applies. So a hearing was necessary and required, and it was an abuse of discretion for the court to deny one. I also want to mention, in the alternative, this court should act to reduce Mr. Clarita's sentence. He was sentenced to 15 years after trial. The pretrial offer was either 6 or 7. 9, I believe, counts were dismissed during trial. He was acquitted of one of the counts. This was simply a trial tax, and his sentence should be reduced accordingly. Thank you.
Thank you, counsel. Thank you both.